So I think in our previous class we have discussed about the original jurisdiction and the advisory jurisdiction. The original jurisdiction and appellate jurisdiction. So in continuing with the jurisdiction of the Supreme Court, let us start with the advisory jurisdiction of Supreme Court. So what do you mean by advisory jurisdiction of Supreme Court? See, the name itself suggests that the Supreme Court plays a role of advising. So, what do you mean by advise here? To give its opinion. So, Supreme Court will give its opinion on any question of law made by Parliament or on any issue of public importance which is brought to its notice by the President. So, the Supreme Court plays the role of advisory body, or it tries to give its opinion in the question of law, that means on laws made by Parliament or on any matter of public importance brought to its notice by the President of India. And generally, as we have said now, the Supreme Court is required to express its opinion in two situations generally. One is, any question of law may be referred to Supreme Court if President considers that the question is of public importance. So here, the President of India can bring to the notice of Supreme Court about various issues. For example, as you know that President of India is the signatory authority of all the bills to become law. When such bills come from Parliament to President, and if he is having any doubts regarding such bills or laws, then he can seek the opinion of Supreme Court. Or if President of India comes to an important issue in the nation, then he can seek the advice of or the opinion of Supreme Court. And once Supreme Court is brought such things to its notice, it gives its opinion, right? So maybe on a matter of public importance, or maybe on a law made by Parliament, on any such thing which is brought to its notice by President, later it will give its opinion. And it is not binding for the government for to follow such advice made by Supreme Court. So it is not compulsory. The Supreme Court may give its opinion, but it is not compulsory on the executive or on the government to follow that advice. It is not binding. Okay, Supreme Court opinion is not binding on the government. So whether it is brought through President or whether it is either it is on the law, or whether it is on the a matter of public importance, whatever it is, when it is brought to the notice of President, brought to the notice of the Supreme Court by the President, and later when it gives its opinion, it is not binding for the government to follow such opinions of Supreme Court. And then you may get doubt, then why such opinions are taken? Just no, President will take whenever he needs that legal support, or whenever he needs that opinion support, he will just use Supreme Court. That doesn't mean that it is mandatory for the governments to follow, because the Constitution has given ultimate law making power to Parliament, and now Supreme Court has no role in deciding the or giving its opinions on the laws made by Parliament. Also, in solving the disputes arising out of pre-constitution treaties and agreements which are excluded from original jurisdiction. Suppose a case comes to, or a situation arises on a pre-constitutional treaty. That means before the Constitution came into force, there were many, right, in 1950 January 26 it came into force. So after 3 years of getting independence, there was Constitution came into force. Now, if any dispute arises on the issues which are before the enforcement of Constitution, then on such issues Supreme Court can give its opinion. So on a modern day cases, if they have to refer to, or if there is any issue in the country which is referring to the pre-constitutional times, then on such things, to address the disputes, Supreme Court may give its opinion. So pre-constitutional issues and their disputes can also, or agreements you can call, all such things can also be given under the advisory jurisdiction by Supreme Court. Earlier it was taken away from, the original jurisdiction of Supreme Court. Hence, the Supreme Court can only advise on such issues. So after understanding the advisory jurisdiction of Supreme Court, let us proceed towards the revisory jurisdiction. So the name revisory jurisdiction itself suggests that the Supreme Court will have a revive or review on its own judgments. So under Article 137, the Supreme Court is empowered to review its own judgments and orders. So Supreme Court, on the cases which were brought under its jurisdiction, will pass many judgments and orders. And while passing these judgment and orders, see, after all, the judges who are passing these judgments and all, they are like human beings, but of course, with the highest knowledge in the judicial process, there might be a chance they may also commit some mistakes in passing the judgments and orders. So, Supreme Court, what it will do is, whenever it feels that there are some mistakes in the orders or judgments passed by it, it will try to review its own judgments. So, if something goes wrong with the Supreme Court judgment, or if there is some mistake in the judgment of Supreme Court, there is no chance for anybody in the country to go to any other court because it is the highest court. Hence, the Supreme Court will try to review its own judgments and orders, so that if any mistakes and all are crept in the judgments, they can be rectified. So why do you think revisory jurisdiction is helpful, or why do you think Supreme Court will go for such kind of reviews on its own judgments? Because generally these judgments or orders will be stored as court of record. That means these judgments and orders will be later taken by the lower courts as reference when such similar cases come to them. Suppose a case come to a Supreme Court and the Supreme Court has passed a judgment on it. Similar case during any situation or at any time or in the course of time, if such cases come to high courts or the lower courts, then they can quote the judgments of Supreme Court as reference, and they can give similar judgments and orders as passed by Supreme Court. Hence, Supreme Court will be very careful in passing its judgment. If some mistakes happen, they will try to review it because the other courts may take it as reference in future, as these judgments serve as court of record. So this is about revisory jurisdiction of Supreme Court. So another important kind of jurisdiction that Supreme Court exercises is judicial review. See, under this judicial review jurisdiction power, the Supreme Court will have a very important role in the country. So what is judicial review? So in general, judicial review means the Supreme Court will have power to overturn any law that will have that goes against the provisions of Constitution. So before understanding this in detail, let us see. See, in India, the Constitution can be finally interpreted by Supreme Court. So it is the highest authority of the country which can interpret Constitution. Hence sometimes it is called as the watchdog of the Constitution. That means it will be having an eye on all the other agencies of Constitution, so that they may not try to violate the Constitution. So Supreme Court is the final interpreter of the Constitution and its decision is final. So in implementing the Constitution, the Supreme Court will use judicial review in certain cases or in certain situations. I said it has to protect Constitution. So, in the job of protecting the constitutional provisions, the Supreme Court will use its judicial review power in certain situations. So, what are those situations? Under this situation, the Supreme Court will use this power whenever the central or state governments or legislatures, if they make laws which are going against constitution. So suppose central government or state governments, they make some laws in their respective legislative houses. After making these laws, who knows that they might have included some unconstitutional provisions in it. So Supreme Court, by the power of judicial review, it can review any laws made by such central or state legislatures. And see, simply it will not take up the law and it will try to interpret the law with constitution and it will dismiss the law. It is not like that. So generally judicial review is not exercised by Supreme Court on its own. So if somebody takes active participation and files a case against any law, then the Supreme Court will take up such cases under judicial review and it will try to review the laws. And once if it feels that the law made by the legislative body is going against the spirit of constitution, then the Supreme Court can declare such laws as ultra vires. That means it has went against its limitation of making law. Suppose if Parliament made a law and it is unconstitutional, now Supreme Court calls it as ultra vires. That means the legislative body has exceeded its limit of making laws, and otherwise it also declares that laws null and void, that means invalid. So only when the laws goes against the spirit of constitution, then the Supreme Court can declare such laws as ultra vires or null and void. And such power of Supreme Court is referred as judicial review. Generally such judicial reviews, where the constitution is to be interpreted, the number of judges involved will be 5. So 5 judges will be generally taking up such constitutional interpretation cases. So the Supreme Court has the power to review all such national and state laws, even executive orders, to review and to declare them null and void. So only when they go against constitution, the Supreme Court uses judicial review and it will make them invalid or it will stop them from getting implemented. So if you look at such judicial reviews in India, there are many such judicial reviews made by the Supreme Court, and it held many of the laws made by Parliament. So in 1970, the Supreme Court had declared the following acts of Parliament as null and void. So like the presidential order of concerning derecognition of former princely states. So this is about the pre-independence time where the princely states were existing, and the presidential order has declared them that they were no more like princely states and all. The order was declared null and void, as well as Banking Companies Act 1969 for the nationalization of 14 banks. So this you have studied that Indira Gandhi has made 14 banks nationalized. You might study this in directive principles, to make the banks accessible to all the sections of the country and not to drive them towards the service of majority Indians. She nationalized the banks, but this act made by Parliament was stopped. You may get doubt why such an important and useful law was stopped by Supreme Court. It doesn't stop, but later the law was made in a different way. So why do you think the Supreme Court used judicial review and stopped this National Banking Companies Act? Because many of the shareholders in the banks, they belong to the private sector, and once it is taken up by government, they lose some kind of shares in the market. So they went to court, and it was called famously Cooper's case and all. I'm not going to all those things. So under this concern of this private people's case and all, the Supreme Court said there should be a proper compensation for such people, and later you can implement the reforms in banking sector. So for such time it held that no compensation is very important as per constitutional terms. Hence the act is not dealing with any compensation for the shares, and it is not guaranteeing anything for the people who are losing because of governments taking up the banks. Hence, to address such people, it held that act, and later that act was made again properly, and it was made constitutional. So this is about the judicial review power of Supreme Court. So why do you think judicial review is needed for Supreme Court or for this country? So the need of judicial review arises to balance the powers of central and state governments. Generally, whenever there is a dispute between the sharing of powers between central and state governments, or if the union government tries to overtake the state governments, and if they try to you know like deprive the rights of the states, or if the states go beyond their limits, and these situations, what happens, disputes arise between central and state governments. So in such situations there is definitely the need of judicial review of Supreme Court. And once a law is made by any state or central government, this can be interpreted in many ways with the constitution. So every person or any court may interpret this kind of laws in different ways. The interpretation level may change from court to court or judge to judge. Now what happens, this law can never be implemented or can never be stopped. So one court may interpret in one way and the other court may interpret in other way. So there is somewhere necessity of the final interpreter of the constitution with reference to a law. So in such situation the Supreme Court is definitely needed with judicial review power, so that with a final interpretation it can save the spirit of the constitution in the laws made by parliament. So with its original jurisdiction power, the Supreme Court can save the spirit of constitution in the laws made by parliament or the local state legislative bodies. So otherwise many interpretations will come for the law. One interpretation will be different from the other interpretation on the law. So there will be definitely a confusion or dilemma will arise. To clear the dilemma and confusion, we require a review of the highest court in the country, so that Supreme Court will emerge as the final interpreter of the constitution, and it will clear that kind of confusions. Generally these situations arise when central government tries to make laws on state issues, when they try to exceed the limit, or when the states try to exceed their limits and not try to involve with the affairs of the central. So when such disputes arise, then Supreme Court will review the law made and it will try to set them in their respective limits, and says, and finally with a vision it comes out that constitution is the supreme authority in the country. And the another reason for having judicial review power with Supreme Court is the legislative bodies may not have, they are they're the law making people, they are elected by people, and now they come from political backgrounds, and now they come through various parties and all. So when they come and involve in the law making process, they may not be aware of the total spirit of the constitution. So as they are legislative people and law making people, they may not be aware of the spirit of constitution. Hence there is a chance that they may be doing some unconstitutional, they may be incorporating some unconstitutional things in the constitution. It is not that they wantedly do it, but sometimes the legislature may not be completely aware of the spirit of the constitution. So at these situations they may they may incorporate some unconstitutional provisions in the laws they make, and hence Supreme Court emerges as a very powerful interpreter of the Constitution in such situations because it completely deals or it completely experiences itself with the laws, constitutional provisions. Supreme Court always functions, based on the provisions, of the Constitution. So it always stays so close with the constitutional and its provisions, and its majority time it tries to protect the constitutional provisions. Hence it has more you know you can call it like it's a best, but Supreme Court is best in the interpretation of the Constitution than the legislative and other wings. Hence, the need for judicial review arises in India, and Supreme Court emerges as a final interpreter, and it uses this judicial review to protect the spirit of the Constitution. So, Supreme Court even serves as a court of record. So we have studied under the, the revisory jurisdiction of Supreme Court, where we understood that the Supreme Court, reviews its own things to correct them. And we have mentioned a point that as Supreme Court serves as court of record, it will tries to revise its jurisdiction, judgments if they go wrong, isn't it? So let us study what is this court of record in detail. So the judgments passed by the judges in Supreme Court are recorded as evidence and testimony. So that means like an examples. So the judgments passed by Supreme Court judges will be recorded. So like what do you mean by recorded here? So they are stored. All the judgment copies will be filed in the office in the form of hard copies, and these judgments are in the nature of precedents, or we call them we spell it as precedent. So what do you mean by precedent? That means it serves as an example for, or it serves like an evidence for the other courts. So whatever judgments passed by Supreme Court, all those judgments are preserved or they're stored. Why are they stored? Because whenever the high courts or any other lower courts, if they get a similar case to them in course of time, if they get a similar case, or the lower courts, if they get a similar case on which already Supreme Court has passed certain judgments, then they have to definitely go through the orders already given by Supreme Court. Supreme Court has passed a judgment and it is recorded now. Similar case has reached a high court later time, and high court what it has to do, it has to look into the judgment passed by Supreme Court. It is a must and compulsion. So they will be taken and they will be referred, and similar kind of judgments are also to be passed by the lower courts. And here whenever such judgments of Supreme Court are given as a precedent or evidence to lower courts by any petitioner, then the courts or the other people cannot deny them. They must and should take them as reference, and nobody can question even such judgment also. So if anybody brings the similar kind of judgment to High Court's notice that, see, the Supreme Court has given this kind of judgment and now why don't you follow this judgment? So if anybody brings to the lower court's notice, and if the lower court cannot question them, or anybody cannot question citing of such judgments of Supreme Court in the lower courts, so Supreme Court shall have all the powers of such, to punish people if they go against their judgments. So even if the lower courts does not refer its judgments in a similar case, and if they violate such citations of Supreme Court, then it comes to contempt of itself. So the Supreme Court even takes the lower court as contempt of Supreme Court, and it can even punish the judges who have not followed it. So it is a very important provision in Supreme Court, and there are two implications for this court of record. So here, how they are understood, or what is the effect of those court of record. See, its judgments and orders are preserved as record, and this can be produced in any court as precedent. One such effect of this court of record is, in any lower court, when such similar cases come, they can easily take, any lawyer who is taking that case can take easily the judgment copy which is stored, and he can directly produce in the court where such similar case has come. So what that was the one immediate effect of court of record. The other effect of such court of record is, if a person contempt of court, the court has the authority to punish him. Suppose if anybody comments on such judgments, or they deny to refer such judgments of Supreme Court, then the court will punish them immediately. So no authority can deny such orders of Supreme Court, or they cannot ignore such judgments passed by Supreme Court. Hence, truly, with all such features, the Supreme Court will act as guardian of the Constitution. So we have seen different kinds of jurisdiction now, and later we'll see the functions of Supreme Court in the later classes.